Good morning to all of you. Welcome to Legal Matters by Sai Bob Sinkara. This time we are going to discuss the proclamation of the case, proclamation of offender, proclaimed offender and attachment of property under section 82 and 83. Normally the judges or the magistrates will declare a person as a proclaimed offender and order for the attachment. They keep quiet. But now the court stated that they have to go for prosecution under section 174A of the Indian Penal Code also. So this is what is held by the Delhi High Court. Right. While disposing the case of Sunil Tyagi versus Government of Delhi and in another case also, in criminal miscellaneous petition number 5328 by 2013 and decided on 28/6/2021. Please remember. So single justice J.R. Midha, MIDDHA of Delhi High Court held that when a person is declared as a proclaimed offender under section 82 and his property is ordered for attachment under 83 CRPC, the magistrate should use his discretion, should be satisfied first, and then if they should make all efforts to apprehend him, and if they are not able to apprehend him, they can file a case under IPC under section 174 IPC, and which is not being followed. This is the main problem. So please remember, justice is the ideal to be achieved by law. The existence of some gap between the law and justice is recognized by the existing law in section 82 and 83 of the CRPC. Now you know the procedure. Section 82 declaring a person as a proclaimed offender. Section 83 attachment is the property. How this is being done? First of all, you have to know. So when any case is there, so normally the court will issue summons. You may be knowing 61 to 69, right? Summons procedure. So if he is able to receive the summons and comes to the court, it's okay. Normally some people, they don't come to the court. Then what to do? In criminal proceedings, yes, the court can issue warrant. Two types of warrants, you know, bailable warrant and non-bailable warrant. Even first, normally the court gives bailable warrant, he will not be available, then they will issue non-bail warrant. So if a person is purposefully avoiding or evading arrest, if a person is absconding, if a person is absent for any reason, then when the NBW, non-bailable warrant, is not being executed, then the alternative left for the court or the police is to declare him as a proclaimed offender. So what is it? According to section 82 CRPC, so you may be knowing a person will be declared as a proclaimed offender if he is purposefully avoiding to arrest, right? Or if he is absent due to so many reasons. Then simultaneously order section 83 will also be given. This is relating to attachment of his property, movable or immovable property. This is a routine thing, right? Then here what happened is the magistrate should not rely immediately basing on the representative of the police. He has to satisfy whether the police made real efforts to trace him or not. First point. Normally police, they will be stating one or two reports saying that we visited the village, nobody has told about his address, he is absconding, he is not available, nobody knows his movements, no relatives are there, his wife is not there, she left for the nearby town, things like they will write. They will be writing like this. Of course, court has to believe them. At the same time, but the court has to satisfy. Simply basing on the report of the police, they cannot declare the person as a proclaimed offender under section 82 of the CRPC. So the magistrate declared him in this case as PO without satisfying as to the factum of service of notice of the plaintiff. Of course, service of notice was not done and no corrective address was given. So this is the thing. This happened in the year 7/1/2000. Of course, it happened in the year 2013. Later, on 7/1/2021, Delhi court actually quashed the petition because the approach or the satisfaction of the judge is not correct. So, Advocate Gopal Sundaram, he said that this is a CBI case in which the accused are there involved in CBI. Now they have appeared, they wanted to appear before the court and get the proclaimed offender notice withdrawn. So in the notice, please remember, it will be written, it will be fixed in a public place, and to the court and to the police office, police station also, stating that Are Baba, a warrant has been issued against you. If you are willing to come, so come and report or surrender before the court within 45 days. Otherwise, your property will be attached. Like that. Property, if at all got property, it will attach. If not, Revenue Recovery Act will take in place. But here, people, they are silent. Court is satisfied that by issue of 50, 82 and 83 notice, their job is done. Police, yes, they have gone and come back, there is no trace gone. But here the important point missing is, you have to take action under section 174A IPC. The investigating officer should check the address, real address, and actually address of the relatives also, address of the second family also, and they have to circulate the photographs also. So don't say that mere non-availability, he is not available, it is not sufficient. Ultimately, if he is not traced, they have to go for prosecution. Simply keeping the file 82 to 83 is not sufficient. CRPC is only personal aspect. What is the substantive action you are going to take? Yes, by taking action on section 174E of the IPC. What is 174? You all know that not carrying the orders of the public servant. So magistrate, when he gives some orders, you have to oblige. If you don't care, if you avoid, if you purposefully take shelter, definitely it is an offence in section 174A of the Indian Penal Code. Of course, the punishment is 1 year or 7 years also. I think offence 3 to 7 years is a very big offence. Of course, only thing is you have to make out a good case, then definitely he will be given punishment also. So normally people are losing track of 174A. To emphasize on this only, I am making this video. So the judges should not be satisfied by issuing 82, 83 notices. The police should not be satisfied that he is not there, and they can initiate criminal action or penal action against him under section 174A of the Indian Penal Code. This is what is stated in the case of Sunil Tyagi. Of course, this man is involved in the CBI case. Proclamatory notice was given to him. He did not attend the court. Straight away, he wants to take shelter. Sunil Tyagi versus Government of Delhi and others. Please read the case law and enrich your legal knowledge. Thank you very much.